Having a child is an amazing experience with so many things to consider and plan for. Today's families are often very different than families from even just a few years ago, as society and technology have progressed to make it easier for those who want to start a family to do so. In New York, if the birth parent is married at the time of birth, the spouse is considered the legal parent of the child. If a child conceived naturally is born to unmarried parents, or the child was born as a result of assisted reproduction to parents using medical procedures to produce pregnancy, both parents can voluntarily sign an Acknowledgment of Parentage form, commonly called an AOP. This form legally establishes who a child's parents are. It has the same legal force and effect as a court order determining the child's legal parentage, and establishes the duty of both parents to provide support for the child. This means that if the Acknowledgement of Parentage is not challenged, the birth parent does not have to go to court or to an administrative proceeding to determine or confirm the identity of the child's other parent. Before signing the AOP, each parent must understand what they are signing. By signing, both parents are indicating that they understand this is a voluntary process, that it has the same force and effect as a court order, that they have received oral and written notice of their rights and responsibilities, and that the information they are providing is true. You have a right to seek legal representation and supportive services, including counseling, to help you decide whether to sign the Acknowledgement of Parentage. Only 2 people can sign the Acknowledgement of Parentage to add the other parent to the birth certificate. For a child conceived naturally, it can be signed by an unmarried birth parent and the alleged parent. For a child conceived by assisted reproduction, it can be signed by a married or unmarried birth parent and the intended parent. The child may be given the last name of either parent or any combination of those names. The child's name will not affect the child's legal status. The AOP can be signed right at the hospital immediately after the baby is born, or later at your county's local social services district office, another location such as a lawyer's office, or at home. If you sign the form at a hospital or social services district, the original Acknowledgement of Parentage will be filed for you with the registrar of the district where the birth certificate is filed. If you do not sign the form at a hospital or social services district, you must mail or take the original Acknowledgement of Parentage to the registrar of the district where the birth certificate is filed. If you are uncertain where the birth certificate was filed, check with the hospital where your child was born. The registrar will mail you a certified copy of the Acknowledgement of Parentage and will also file a copy with the Putative Father Registry. This is a state registry where acknowledgments of parentage and other related documents are filed. Information in this registry shall be released to a court or authorized agency upon request, but shall not be released to any other person without a court order for good cause shown. Note: the Acknowledgement of Parentage includes a section to provide the name and address, if known, of a gamete, sperm or egg, donor of a child conceived through assisted reproduction. When this information is provided, the State Department of Health or the New York City Department of Health and Mental Hygiene is required to mail a copy to the donor with the social security numbers of the child's parents redacted. The AOP legally establishes the rights of both parents and allows them to share parental responsibilities. It gives the other parent the right to have their name on the birth certificate and the right to be consulted in the event of future adoption. And along with the emotional benefit of connection with both parents, it also allows the child access to medical information, as well as financial and insurance benefits from both parents. Establishing parentage for a child lays the foundation for any future need to formally request a child support order or an order of visitation from a court. Bear in mind that determining child custody and visitation rights will require separate hearings. It's important to understand that the Acknowledgement of Parentage is a legal document. If you aren't absolutely sure who the other parent is, do not sign the form. If you have any questions, you should talk with someone in the birthing unit of the hospital where your baby was born, your local child support agency, or county birth registrar, or even a lawyer. Signing the AOP is voluntary. Do not sign an Acknowledgement of Parentage if the birth parent of a child conceived naturally was married when the child was born. The birth parent is unmarried, and more than one person could be the other parent. A court has entered a judgment or order determining parentage for the child. A valid acknowledgement of parentage, formerly known as acknowledgment of paternity, has been signed for the child. The child is the subject of a surrogacy agreement. The child has not been born, or there are already two parents on your child's birth certificate. When parents sign the AOP, they give up their right to a court hearing to determine parentage, may establish custody and visitation rights, and may be required to give consent before the child can be placed for adoption. The child's right to inherit from both parents is established if the acknowledgement of parentage is filed with the registrar in the district where the birth certificate was filed, and the child's right to inherit from both parents may be established if the acknowledgement of parentage is filed only with the putative father registry. If an AOP is not signed by both parents, then the other parent's name can only be added to the birth certificate after parentage is established in court. If the court determines the alleged or intended parent to be a legal parent of the child, the court may make an order of support, which may be retroactive to the birth of the child. If a court hearing is required because both parents do not sign the acknowledgement of parentage, the alleged or intended parent may have a right to free legal representation if they are unable to pay for a lawyer, and an alleged parent has a right to a genetic marker test or DNA test. If the birth parent applies for or receives public assistance, that parent's refusal to sign the acknowledgement of parentage cannot be considered a failure to cooperate in establishing parentage for the child. An acknowledgement of parentage is void at the time of signing if a person other than the party signing the acknowledgement of parentage is a presumed parent of the child due to marriage. The child has a legally recognized parent other than the party signing the acknowledgement of parentage due to an assisted reproduction agreement. A court has already entered a judgment or order determining parentage for the child. Another person has voluntarily acknowledged parentage for the child. A person signing the acknowledgement of parentage was a donor in an assisted reproduction and already signed a statement that the donation was not intended to result in parental rights and responsibilities. Or, a person signing the acknowledgement of parentage asserts they have parental rights due to an assisted reproduction agreement, but a court finds that the child was not conceived through assisted reproduction. Even if both parents do voluntarily sign the AOP, it can still be rescinded. Either parent has the right to file a petition to vacate the acknowledgement of parentage with the family court. The petition can only be filed within the following time limits, depending on whether you're 18 years old or younger than 18. If the parent was 18 or older on the day the AOP was signed, they can file a petition within 60 days of signing the AOP, or by the date on which an answer to a petition is required in a proceeding relating to the child and in which the parent is a party, whichever is earlier. If the parent was under 18 years of age on the day the AOP was signed, they can file a petition within 60 days after their 18th birthday, or by the date on which an answer to a petition is required in a proceeding relating to the child and in which the parent is a party, provided that they were advised at the proceeding of their right to file a petition to vacate, whichever is earlier. If more than 60 days have passed since signing the AOP, parents of any age can only challenge it in family court if it was signed based on fraud, duress, or material mistake of fact. The burden of proof is on the party wishing to withdraw the acknowledgement of parentage. If the petition is filed within the timeframes, or the petitioner proves fraud, duress, or material mistake of fact, a judge will order genetic marker tests or DNA tests to determine the child's parentage. The court will not order this testing, however, if the acknowledgement was signed by the intended parent of a child born through assisted reproduction, or if the court finds that it is not in the best interest of the child. Neither parent's legal obligations, including the obligation to support the child, may be suspended during the challenge to the acknowledgement of parentage, except if the court finds good cause. If the genetic marker or DNA test confirms that the person who signed the acknowledgement of parentage is a parent of the child, the court shall make a finding of parentage and enter a judgment or order of parentage. If testing shows the person who signed the acknowledgement is not the parent of the child, the acknowledgement will be vacated, and the court will immediately provide a copy of the order to the registrar and to the putative father registry. If a party is receiving child support services, a copy will be provided to the Child Support Enforcement Unit. Please note, the information and statements contained in the Acknowledgement of Parentage will not be verified by any state, local, or private entity before or after a birth certificate is created, or the document is filed with the putative father registry, as no requirement to do so is provided in law. Signing a voluntary acknowledgement of parentage is an important first step to protect the rights of the parents and the child. For more information on filling out the Acknowledgement of Parentage form, including step-by-step instructions, check out the other video in the series, Completing the Acknowledgement of Parentage form, on our YouTube channel. You can also visit the Office of Temporary and Disability Assistance, Division of Child Support Services webpage at the address on your screen.